Excuse me.
Court is open. Please be seated.
All right. Our next case is Ralph V. Ladd versus ARBELLA Protection Insurance Company, docket number 23P1427. Good afternoon.
Good afternoon. May it please the court. My name is Patrick Sullivan, and I represent Ralph V. Ladd. Your Honor, the underlying situation was a construction project in New Hampshire that Ralph V. Ladd was not involved with. When we look at the complaint, the plaintiff starts out, it was a counterclaimant homeowner brought Ralph V. Ladd into the case, and she concedes that Ralph V. Ladd is a sole proprietor. She concedes that his son is a sole proprietor. And then she kind of just kind of mushes them together for the rest of the complaint. And
I mean, the facts are very odd, right, in terms of the decisions that Bosch made. But I guess one of my questions, and the judge did allow the record to be expanded, right, to include the Middlesex lawsuit. Your client received a judgment, right, on the abuse of process claim?
Yes.
How, if at all, does that impact the insurance company's coverage issue? I mean, is your client whole?
Well, no, because there's another appeal. I think the report date for that is today, coincidentally, so my client is not whole.
So what's the other appeal? Not the substance, but which?
Bosch has appealed the abuse of process claim. And, I think that's really a collateral source kind of argument,
If
right?
hypothetically she loses her appeal, I have no idea what will happen with that appeal. Is your client whole?
Well, then you have to collect.
Right.
So it doesn't, I don't think that excuses the insurance company. I think this is something like a collateral source situation. They can't have it, a collateral, it's good for the goose, good for the gander in that kind of a scenario. They could maybe say that we want Ralph V. Ladd's rights against her because those were legal fee damages and we want to take those, but pay Ralph V. Ladd. And then you, Mr. Insurance, Mrs. Whatever, you insurance company, you go chase that because we paid for insurance. And you should have showed up for something more than just sitting in the back of the courtroom during the trial, which is what they did.
Do you agree, let's get to the merits of your case, do you agree that the breach of contract and the breach of the covenant of good faith and fair dealing are not covered by the CGL policy?
Yes.
So what is covered, you're saying, are the claims of negligence?
Negligence, very broad brushed, with multiple trades, and the insurance company knows that Ralph V. Ladd's in the plumbing repair business. And so in the complaint, she's alleging that there was structural damage caused to her property by the structural contractor. She's got multiple trades. She's not saying that Ralph V. Ladd and David V. Ladd have a joint venture. She says they're sole proprietors. So even if they were a joint venture, she's not saying that they're joined at the hip for all intents and purposes. And she's not saying that they were doing all the work together. Now, it turns out that Ralph V. Ladd was never up there, and that really is the significance, I believe, of the abusive process, because if the standard is extrinsic evidence, what is known or readily knowable to the insurer, it's presumed that the insurer knows who they're insuring. And what the business.
So the black letter law here, the first principle seems to be that you take the duty to defend is defined by the allegations. And so I read her allegations in her third-party complaint, and I don't see, well, I'm asking you to focus my attention on a record site in her third-party complaint where she alleges something that's covered by the policy.
She's alleging the policy covers property damage. And the policy, we have to have an occurrence, property damage, coverage territory, and the one thing the insurer does concede is that New Hampshire is in the continental United States, so we get by on the coverage territory and during the policy period, and the policy periods overlap. But the third-party complaint, and I apologize if I know I have it cited in my papers, she absolutely alleges property damage, and she's talking about structural work, and she's talking about damage that's caused as a consequence of the other work. So even if this was something that was Ralph V. Ladd's work, and he might not be covered for his own, what they call his own shoddy work.
What is the occurrence is an accident, right?
Yes.
What is the occurrence here that is separate and apart from quote-unquote shoddy workmanship as a matter of law?
she's claiming, well, for one that jumps out to me is the structural. She's claiming because the structural work was done improperly, and Ralph Willett has insurance for the consequence of negligent conduct of others, or, on all of his projects, and so certainly he has it on this one as well, but she's pointing to structural work. She's saying the structural then caused damage to other parts of their house, so even the structural contractor...
Wait a minute, I'm sorry to cut you off, but where does she, that seems important, it's causing damage to other parts of her house. I didn't read that, and so I may have missed it, but can you give a record citation to where she alleges that?
I have it in my papers, Your Honor. I'm sorry, I don't have it off the top of my head. The problem with her complaint is she's got so many different things in there in such a smorgasbord, wide-open thing that to say that it would be impossible, because that's the standard.
No, that would be good for you. If to me, it seems under the law. If it was a wide-open smorgasbord of allegations, then you could pick out the ones that are covered by the policy. But it seems to me it's not. It seems to me all of her claims of damage to the property are about the shoddy workmanship. In other words, there's a distinction between shoddy workmanship that requires the repair of the workmanship itself and shoddy workmanship that causes damage to other parts of the property, which you keep calling structural damage to other parts of the property. My reading of the complaint is she alleges the former but not the latter. And I keep asking you to focus on where give us a record site to where she does that.
I have to rely on my papers, Your Honor.
Thank you.
Unless there's any other questions, I will rely on my papers.
I have one more question. Do you agree that the 93A claim is contingent on our finding that ARBELLA had a duty to defend?
As a practical matter, yes, Your Honor. What we had an agreement is that let's deal with the duty to defend, and then we'll deal with damages, and then we'll deal with the 93A. So it all kind of, I think that if I don't get past the first domino, it's game over.
I think that's right. Okay, thank you.
Your Honor, there's one other point I just want to make, if I may. One of the things that runs through these cases is the idea that whether or not someone has coverage for something, usually, in the usual scenario, you can tell it just by looking at the complaint. So one of the big cases that I found interesting was, and I don't know how to pronounce his name, Marcoletio, and the standard was it was a ballet teacher who brought one of his students to Romania, and she claimed she was assaulted. And
I read the case. I'm familiar with it.
So in that case, let's say that he does, these policies exist. I have a policy for, in that case, he had no coverage under any scenario. It would be impossible. But there are policies out there for sexual misconduct if you get accused of it, like kind of a defense thing. And let's say that the exclusion in that policy was anywhere in the world except for not Romania. And she puts in her complaint that it happened in Romania. And his defense is, we never left Logan Airport. I'm in the coverage territory. I never left it. We got all sorts of proof, and something that's readily available because we got TSA, we got all sorts of things. The plane never left off. He never goes to Romania. And now she proves it. They said, no, she said it was in Romania. Well, the insured would think that he has coverage in that scenario, and that's like they want to use the get-out-of-jail-free card without looking, knowing full well, and this is where I start to get to my 93A, that they knew full well what this man's business was, because they're insuring, he's 84 years old, they've been insuring him for years. They know he's in the plumbing repair business, and they know that. So that's, I don't want to take up any more of your time. Thank you.
Thank you very much. Attorney Dunlap.
Good afternoon, and may it please the Court. Ben Dunlap for the defendant, appellee, ARBELLA Protection Insurance Company. Summary judgment for ARBELLA should be affirmed for 3 reasons. First, there is no duty to indemnify or defend Ralph Ladd because the allegations in the third-party complaint clearly allege shoddy workmanship by Ralph Ladd as the sole basis for the negligence count against him, and damage to property that Ralph Ladd was performing operations on. The your work exclusion, the your property exclusion, and the exclusion J, property on which you're performing operations. Those three exclusions clearly apply and bar coverage for the claims in the third-party complaint. Second, with respect to the claims of breach of contract, defrauding, intentionally fleecing, fraud and deceit, and so forth, violation of the New Hampshire Consumer Protection Act. First, we've heard that the plaintiff appellant has conceded that, at least as to the breach of contract claims, no coverage is alleged to exist, so that's out. But similarly, the fraud and deceit claims and the like are expressly barred by the expected and intended acts exclusion in the policy, and as well, they don't constitute an accident. They're not an occurrence under the policy. So there would be no coverage for those claims in the first instance.
So is part of your argument, well, let me ask it this way. If someone is sued for something they did not do, can there be insurance coverage?
Well, Your Honor,
And I'm talking about duty to defend.
Sure, understood, which is broader than a duty to indemnify, which we acknowledge. The answer is maybe, but it depends on what the allegations in the complaint are in the first instance, and whether those allegations match the coverages under the policy.
And let's assume the allegations are made up out of or they're just wrong. Maybe they're made in good faith, but they're just wrong. And let's assume that the insured has to spend literally years defending this until someone finally gets it right. They're just, pardon the expression, they're just SOL because the plaintiff got it wrong?
The plaintiff can get it wrong, Your Honor, because what governs the defense obligation is not the dispute between the plaintiff and the defendant and whether the plaintiff is telling the truth or not, whether the allegations by the plaintiff are true. What governs the duty to defend is the insurance contract between the insured and the insurance company. And so with respect...
So are there insurance contracts that cover someone who is incorrectly sued or improperly sued in a situation like this? Is there such thing?
Well, sure, Your Honor. For example, I'll give you a hypothetical. If the allegation were Mr. Ralph Ladd came to the property, he dropped a hammer through something and broke something that's other property, it's undisputed. The plaintiff herself, Ms. Bosch herself, alleges that Ralph Ladd negligently dropped a hammer through something, broke something he wasn't working on, wasn't part of his work, wasn't part of, quote, the work. He wasn't performing operations on it. No exclusion applies, okay? And let's say those are the allegations. Let's say Ralph Ladd says, I wasn't there, and it never happened. That's the dispute, right? Potentially there's coverage whether Ralph Ladd acknowledges it or not. But what it doesn't depend on is Ralph Ladd's denial. Okay? So
you see the irony here, though, right? You're better off being there and screwing up, frankly, than you are when you're being sued for absolutely no reason whatsoever.
Well, respectfully, Your Honor, the plaintiff here makes a lot of the fact that Ralph Ladd denied the allegations, and he submitted an affidavit. However, the underlying dispute, the plaintiff, Ms. Bosch, never acknowledged, never conceded ever that there was anything but a dispute. And the judge in the underlying case, there's not much of the record that was allowed in, which I think is appropriate, but there is the judge in the underlying case denied summary judgment on the basis of disputed facts. So there was a dispute between Ralph Ladd, the defendant, and Alina Bosch, the claimant. So it was not an instance where it was undisputed that the insured didn't do what he was alleged to do. So that's a hypothetical we don't have in front of us.
Under your argument, it wouldn't matter anyway. We just look to what's in the complaint.
That's correct. And
match it up with the terms of the contract. That's what the case law instructs us.
That's what the case law instructs. And there is a carve-out, which, again, we acknowledge for extrinsic evidence. That's the Billings case. Extrinsic evidence that's undisputed. And here, again, it's not undisputed. And the mere fact that the insured puts in an affidavit, well, Your Honors, every insured could put in an affidavit denying the allegations in the complaint, and that surely that can't be the law that it's sufficient to create coverage where none exists simply by denying the allegations against the insured.
I guess I have I feel like there's got to be an obvious answer to this, so I apologize if there is. But if we're at summary judgment stage, and generally at summary judgment, you're supposed to take the non-moving parties or losing parties' facts as true. And if Ralph Ladd in his affidavit denied being present, is that a reason, and does the judge on summary judgment have to accept that as true and deny summary judgment for that reason?
Your Honor is referring to summary judgment in this insurance coverage action, not the underlying action.
Yes.
Yes. Thank you, Your Honor. We would submit no, that it's not accepted as true. It is accepted that he made the affidavit. I think that part can come in as that he made the affidavit, but the fact that the affidavit is disputed is also part of the record. The dispute is part of the record that the judge has to consider. So it's not an undisputed fact. It's knowledge of the insurance company. And even if it were undisputed, that alone cannot create coverage where none exists. Let me take it to the next level, if I may, Your Honor. What Ralph Ladd essentially is asking for, what he is contending in the coverage action is that he should be defended because Alina Bosch is not claiming he did anything wrong, that he didn't do anything wrong, it was his son David. All of the liability is on his son David. Let's accept that as true for the moment. If that's true, that Alina Bosch's entire claim is against David Ladd and not against Ralph Ladd, then there is no coverage under this policy. The sole policyholder is Ralph Ladd. There's no coverage for any liability of David Ladd. If it's correct and true that David Ladd did everything, and David Ladd is solely liable, then we just have to look no further than the insuring agreement. The insuring agreement of the ARBELLA policy, that's Record Appendix 151, we will pay those sums that the insured becomes legally obligated to pay as damages. The insured, not David Ladd.
I think I have that. I have a different question. In your brief, you talk, and this is helpful to me, but it's at page 25 of your brief, you cite you cite an unpublished decision, but that in turn is citing a law review article, and it draws the distinction between insurance, the kind of insurance we have here for tort, essentially, accidents, and what's known as a business risk. And what I'm wondering is if ARBELLA at the time of this, and I think you would say that shoddy workmanship is a business risk and not covered by this kind of policy. And so I'm wondering, first, if it was within the power of Mr. Ladd to address this problem by buying the right kind of insurance for shoddy workmanship. In other words, did ARBELLA sell a policy at this time to protect from the consequences of shoddy workmanship?
I have two answers, Your Honor. The first answer is that there's always insurance for everything. It's just a question of finding the right person to provide it. But I think the more basic answer is probably no. It's probably no, because, again, typically a CGL policy, even with endorsements, is not going to cover business risk because that is meant to be the contractual relationship between the contractor and the customer. And if you perform the shoddy work, that's between you and the customer. If you have to redo it, that's your contractual obligation. It's not an accident. It's not an occurrence. There's a difference between shoddy work that causes an accident and the performing the shoddy work itself, which is not meant to be insured.
I get that. Thank you.
I did want to also address the assertion or the arguments concerning ARBELLA's knowledge of Mr. Ladd's profession. Yes, ARBELLA acknowledges and understands Mr. Ladd as a plumber, but it's also possible, as happened here, that a third-party plaintiff in a complaint alleges that an insured does something that it's not part of their business, which may or may not be covered by a policy. So simply the fact that Ms. Bosch alleges structural damage, and she does by both Ladds, she alleges, this is on Record Appendix 186 through 188, the lads, plural, performed the structural construction work at the property in a negligent and grossly negligent manner. She's not saying David Ladd did it. She's not saying some other person did it. She's saying the lads, including Ralph Ladd. So,
If I could just, I read that. I think, well, the word negligent, I think that is confusing to the non-insurance expert. If the general rule is this covers tort, I go back to law school and I hear the word negligence, I think that's a tort. But I read this and it also, we also don't cover shoddy workmanship. It seems like she's calling it negligence, but it's really shoddy workmanship. Is that, do you read it that way?
that's correct, Your Honor. And typically, a plaintiff is going to allege negligence, and then how we would review it is what is the plaintiff claiming was done that was negligent? And here, she's alleging the negligence was performing the shoddy work.
Right.
And so that's how where we get to negligence might get you to the land of occurrence, but then when we go into the policy exclusions, which are then applied to the claim, that the negligence claim, to determine whether they are or are not excluded. And here we contend they are excluded. I could, there are, as I say, on pages 186 through 188 are specific examples of the allegations in the third-party complaint, detailing specifically what Ralph Ladd was alleged to have done. With respect to the, again, the denial by Ralph Ladd, we would rely on the language of the Marcoludi case, which again says that the defendant's denial does not create coverage. With respect to the court's question about the outcome of the underlying case, we contend it has no impact on the determination of the insurance contract between Arbella and the insured. And finally, with respect to the Chapter 93A claim, I agree with Mr. Sullivan that the parties did agree at the time to put off briefing of the 93A issue. And also, I would say this record is sufficient for the court to determine there's no basis for a Chapter 93A claim. Even if the court were to disagree and find that there were coverage, whereas here, the insurance company has a well-reasoned position that it's communicated to the insured. The case law is that, and that's the Guiti versus Commerce Insurance case cited in our brief. That takes it out of the area of the punitive aspect of Chapter 93A. So even if an insurer is mistaken, if it's made a mistake in good faith, it takes it out of 93A without further determination.
Final question from me. If the underlying complaint had alleged that Ladd performed shoddy workmanship in the plumbing, which caused the pipes to break and water spilled out, ruining the entire electrical circuit, which had to be rewired at a cost of X, would that be a sufficient allegation of negligence for a duty to defend to kick in?
Your Honor, if the electrical items, the circuit and so forth that were damaged were not Ralph Ladd's work, probably there would be coverage in that instance. Where some other aspect of property that's not the insured's work, or not part of it. For example, when
my larger question is that would constitute an occurrence.
Yes, Your Honor.
And it would constitute property damage. Understanding that hypotheticals are imperfect.
Yes, Your Honor.
Okay.
And the one thing I would say is often when an entire home is being constructed, the entire home is the work. And so if it's a new circuit board and someone breaks it during the construction process, that's potentially not covered because it's your work. But I think in Your Honor's example, the answer would be yes.
I don't see any other questions, so I think we're going to have to leave it there. The matter is under advisement. Counsel very well argued. Thank you. That concludes today's special sitting of the Appeals Court. I want to thank our court staff, in particular our court officers, our law clerks, and our wonderful timekeeper. We are in recess.
Thank you.